Hello everyone, welcome to today's session. Before we dive in, I would like to clarify a few things about this program and how to extract maximum value from it. Now, what is our understanding about plain English? Why would someone want to learn the art of writing in plain English? In fact, the opposite may be more attractive. Everyone aspires to draft documents in a complex legalese and filled with distinct vocabularies to show off one's knowledge. But what happens when you use complex legalese? You create a space between you and the reader and the intended message. The research shows that when you use such artificial language, you alienate your reader. The message that you're trying to convey get lost with the too many ambiguous words. It may be attractive to show off on Twitter, but using such pompous legalese will only make you look immature. Remember, our goal is not to make a show, but to persuade your reader to take some action. And it is possible only if you're able to write in clear, concise, and well-written English. As Sir Ernest Drawers, the prominent advocate of plain English movement, in his book, The Complete Plain Words, he says that the true test of writing is whether it can convey exactly what we intend to convey. Hence, it becomes important that an advocate can write in a way that is intelligible to others. If you write in poor English, there's a risk that you will fail to convey your intended meaning to your readers. And most likely, poor writing will distract the attention of your reader from your intended message. Now, this puts a lot of problem to your cause, to your arguments. That is why you must adopt the principles of plain English reader writing, because it makes it easier for the reader to understand the content in the first reading itself. The use of plain English shows the signs of clear thinking, because by using clear, concise, and accurate language, by ordering points logically, including only what is necessary and cutting out the excessive words, by preferring active voice over passive voice, by using clean design to make your writing more attractive and easier to follow. The need for plain English is much more important in fields like law, medicine, and healthcare services, as many lives depend on it. Unfortunately, both legal and medical professionals have made a name for themselves for illegible writing style. This put a great burden for the layman to understand both medical as well as legal documents. It is highly likely that you may find a petition, statute, or a judgment to be incomprehensible because of poor English language principles, such as excessive words, passive voice, and too many legal jargons. This routine problem leaves litigants, academics, students, and the general public feeling alienated without the right to clear information. In describing this problem accurately, someone once said, by writing as we do, we unnecessarily baffle our clients, mystify our work, and alienate the public. We could change this, and we should. Such a golden words. After a very long battle, India finally enacted a law called Right to Information Act in 2005. However, RTI will become redundant if the information itself is incomprehensible. Hence, there is a need for a movement similar to RTI, Right to Clear Information, that mandates plain English writing be used across all branches of the government, whether it is policies, statutes, circulars, rules, notifications, and even health awareness campaigns. The former US Vice President Al Gore once said, "Clear writing from a government is a civil right." His initiative ignited a movement within branches of the US government to adopt and prioritize clear and concise writing in all legal documents. As citizens, as legal professionals, we need to demand the government to implement plain language initiatives. This course is an attempt to kickstart such a movement in India for clear legal writing. As legal professionals, it is imperative that we start this initiative in our own work, whether it is drafting petitions, memos, demand notices, or any other legal documents. To do this, we need to start rewiring ourselves to shift from old-fashioned and archaic language to simpler, clearer, and modern English language. Though it might not be easy, we must start somewhere. The movement will require continuous and conscious effort to identify and be aware of such muddled and mind-numbing jargons. We need to be aware of our own writing style before we could make a change. There is no magic wand to instantly become a clear thinker and writer. It takes practice. Fluency comes in part from familiarity with the skill of writing. You must commit to complete the exercises, assignments, and incorporate changes based on our feedback. And you'll see the progress in time. Also, not everyone will appreciate your efforts towards a clear and concise writing. So you may face certain obstacles initially, but the idea is not to be too rigid in our approach. For example, although I am aware of these principles and more than convinced the need for plain English legal writing, I still give in and use certain wordy expressions, legalese, as demanded from this profession. There's years and years of habit built into the system. So I know that I can't change the entire system in a single day. So little by little, I try my best to incorporate these principles into my work. There may be the impression that plain English, because of the word plain, means it's boring. But the fact is, it isn't. A client who receives an opinion written in a poor, illegible English will think twice before sending any more work. So, using plain English principles, you're trying to communicate clearly and precisely by eliminating excessive words, by using active voice over passive voice, by removing redundancy and cutting out qualifiers which adds no meaning to your sentences and making your text easy to read. It focuses on what is important for the readers. Make them see what you want them to see. Persuade them to do what you want them to do. That is the goal, the purpose of your writing, isn't it? In this program, we'll review some of the technicalities of the English language, such as construction of sentences using grammar and syntax. However, this program is not an extensive rules of English grammar course. Instead, the goal is to try to identify mistakes which are commonly made and to show how these mistakes may be avoided. We'll go in depth on the principles of plain English legal writing using persuasion and clarity. We will look at the writing style of Aristotle and Cicero, the master persuaders. Their lessons on persuasive rules for argumentation is the basis for much of what we are learning. It deals with three components such as logos, pathos, and ethos, which makes your argument strong and persuasive. Some important pointers to keep in mind to improve your writing. Always think of the person you are writing to and why you are writing. You must have an objective before you even start writing something. You need to ask yourself what words, phrases, or concepts the person is likely to know already, and what tone and level of detail is suitable, and what message they're supposed to get from your information. Point number two, be personal and direct. Use words that communicates as if you are interacting with them on a one-to-one basis. Avoid writing from a third person narrative. Point number three, keep it simple. Try to avoid using corporate language in public documents. It is not necessary and it is also very distracting for the reader. And avoid wherever possible complicated terms if a simple alternative word is already available. Point number four, define or spell out any unavoidable jargons or abbreviations, especially in contracts and agreements. By defining in the beginning of the document, it helps the reader to understand the context of using such words as he goes through the rest of the document.